Hi, I'm Leanne McGahee.
I'm Mary Ayla.
Today we are going to discuss do not resuscitate, end of life, and OLS requests. Do not resuscitate.
What does DNR mean? A DNR is a legal or medical order that states that in the event that a person's heart stops functioning or if they stop breathing, they are not to receive life-saving measures such as chest compressions, electrical shock via defibrillator, or artificial breathing tubes. A DNR may also be called no code or allow natural death. The person is to continue receiving all other care and treatment as usual and necessary. Some facilities may also request a DNI order, which is short for do not intubate. A DNI is not necessary because a DNR already covers artificial breathing tubes. If you ever have issues with a facility or a physician who tells you otherwise, please let us know and we will clear it up with them.
Division of Guardianship Life-Saving Measures SOP. If the cabinet has been granted the authority by the court to make healthcare decisions, the client's code status will always be full code unless the client had executed an advance directive prior to being declared disabled, a healthcare surrogate designated by the client has executed an advance directive, a prior court-appointed guardian of the client has executed an advance directive concerning the client, a cabinet nurse consultant has determined the client meets criteria as defined by the cabinet protocol for making healthcare decisions to be changed to code status of do not resuscitate.
Who qualifies for DNR code status? Anyone who has a terminal condition that is incurable, irreversible, and will result in death. Anyone who is permanently unconscious, and anyone who has 2 or more coexisting medical conditions that compromise their chance of recovery or of benefiting from resuscitation. If your client meets this criteria, please discuss the matter with the facility case manager, physician, or nurse to educate them on the process. Too often, it is put off until it becomes an urgent matter, and it is the client who suffers the most when that happens.
Some physicians may request a DNH order. DNH stands for Do Not Hospitalize. We do not approve DNH requests. While frequent trips to the emergency room could be very taxing on someone who is at the end of the life, there are times a trip to the emergency room is necessary. Say a client falls and hits their head. Head wounds bleed a lot. The client requires stitches. They need to be taken to the emergency room for treatment. While most facilities would understand this, unfortunately there are some that would not. For this reason, we do not approve DNH orders.
So, in summary, all clients are full code. To get a client changed to DNR, they must have a prior order reviewed and approved, or the physicians must complete the process with the nurse consultants to request a code status change. There is a process for a client to be changed to a DNR code status. It is not a quick process. If you feel that one of your clients meet the criteria for a DNR code status, please notify the facility and we will send them the information on the process. As the nurse consultants, our busiest time is at the end of the day on Friday. A lot of facilities tend to procrastinate and wait until the last minute to decide that a client urgently needs a code status change. Please assist your facilities in being proactive before it becomes an urgent matter. It is in regulation that upon receipt of the completed request, the cabinet has 3 days to review the request prior to making a decision. Although we typically can have a DNR approved and in the system within an hour or 2 of receiving the completed paperwork, there is a 3-day window that may apply at times. Also, it is very rare that we receive a complete request. We almost always have to call and request something they forgot to send. Once a DNR is approved, Dell nurse consultants will notify the facility both verbally and in writing. Notify the guardian and supervisor via email and update GFIS with all the information. The guardian will need to go to the facility to sign the EMS DNR forms after the DNR is approved. It is recommended to sign multiple copies as these are given to the ambulance every time that a patient is transported to the hospital and they never make it back to the facility. EMS will not accept a photocopy.
A facility staff member contacts you, the guardian, regarding your approval to change a client's code status from full code to DNR. You should
B, give them the contact information for the Dell nurse consultants, or D, get their contact information and notify Dell nurse consultants who will contact them directly. Allowing the facility to work directly with the Dell nurse consultants allows them easier contact to discuss items that may be missing from the paperwork. It is easier to get questions answered, allows you time to work on other things, and ensures that the facilities get the most current and up-to-date forms and instructions. So both B and D are correct. There are times that A is also correct in an emergency. Just please make sure that you have the correct forms. It is preferable, though, when possible, allow us direct contact with the facility from the beginning. C is always incorrect. Please never approve a code status change without it being properly approved.
A facility has a client's code status as DNR, but GFIS lists them as a full code. Their code status is
full code. Always go by what is in GFIS as the official code status. If a facility has a client listed as DNR who is full code in GFIS, please let them know that the code status needs to be changed to full code. If they would like to have the code status changed to DNR, they will have to follow the process or have a prior signed DNR reviewed and approved. Please take time during your face-to-face visits to check with facilities to ensure that they have the correct code status for your client.
a facility states that they have a DNR order that was signed prior to the client being appointed to guardianship. The facility must submit the signed DNR in order for it to be reviewed and approved or denied by either Jessica Wayne or Mike Handy. True or false?
This is true. If the client had a prior existing DNR, living will, or advance directive, these must be submitted to the cabinet and be reviewed by either Jessica Wayne or Mike Handy. Jessica or Mike will either approve or deny the prior existing order and notify the Dell nurse consultant, who will then enter the information in GFIS as an event and update the face sheet. Please ask the facility at the initial face-to-face if the client had DNR code status prior to being placed with guardianship.
Some reasons that a prior existing DNR order may be denied. Incomplete form. It may be missing dates or signatures. If the form was signed by the client after they were referred to the cabinet due to their inability to make their own decisions. If the form was signed by an appointed healthcare surrogate or next of kin who is suspected of abusing or exploiting the client, they may not have had the client's best interest in mind.
With a signed DNR in place, this means that if the client's heart were to stop beating or they were to stop breathing, no actions will be taken to restart their heart or restart their breathing. True or false?
This is true. If a person has a DNR code status, they will not receive chest compressions, they will not receive an electric shock to their heart, and they will not be placed on mechanical ventilation for respirations.
With a DNR code status in place, it is expected that the client is still treated for everything imaginable except for cessation of heartbeat and respirations. True or false?
This is true. When a client has a DNR code status in place, they will be treated for everything imaginable except if the heart stops or breathing stops.
The nurse consultant signed the Emergency Medical Services DNR paperwork. True or false?
This is false. Nurse consultants do not sign the EMS DNR forms. This is a paper that must be signed by the guardian after the DNR request has been approved.
When nurse consultants approve a DNR, we call the facility and tell them that the code status change has been approved, and then we send them a written approval. This is an example of what that approval looks like that we send to them.
Most facilities will request an EMS DNR order be signed. The nurse consultants cannot sign this form. Nurse consultants review the requests when they come in and ensure that they are medically appropriate but cannot sign consents on the client's behalf. The EMS DNR order form must be signed by someone who may act on the client's behalf, such as the guardian. The law requires that only a signed original may be accepted. This form may not be faxed or copied. We recommend that you send several while at the facility. These forms must go with the client when being transported from the facility to the hospital. These forms never return with the client when they come back.
That wraps up DNR. Now we will discuss end-of-life care request.
An end-of-life care request is necessary to provide appropriate end-of-life care to an individual who has an irreversible terminal condition, is permanently unconscious, has a combination of medical factors that make death imminent based on reasonable medical judgment. Types of end-of-life care include hospice, which is a regulated set of care standards for someone who physicians estimate to have 6 months or less to live, if this is appropriate for a client who has a cancer diagnosis that has spread to the brain. Comfort care. This is not regulated. It can be whatever the physician's state is necessary to make the client comfortable. This is appropriate for a client with end-stage dementia with chronic respiratory failure who continually suffers from aspiration pneumonia. Withholding of life support measures. This may be necessary for a client who has dementia and has stopped eating as part of the dying process. The physician may request to withhold surgical placement of a peg tube to provide artificial nutrition. The physician may request that the client instead be provided with oral intake even though there is significant risk of aspiration. Termination of life support measures. This means to stop providing life-prolonging treatments such as artificial nutrition, mechanical ventilation, or hemodialysis. This is appropriate for a client who has suffered an acute heart attack that has left them with an anoxic brain injury on terminal mechanical ventilation.
If a client has a DNR order in place, they do not need approval for end-of-life care. True or false?
This is false. A DNR needs to be approved prior to end-of-life care. These two processes are not interchangeable. A DNR only addresses care when the heart stops or breathing stops. End-of-life care is to give someone appropriate care at the end of life to make sure they are comfortable, to ease pain, and allow more enjoyable moments rather than additional procedures and treatments.
A hospice consult may be performed prior to requesting end-of-life care for a client. True or false?
This is true. Hospice consults do not need approval. Hospice consults are only for the hospice staff to determine if the client is eligible for services according to their standards. You also do not need to sign consents for a hospice consult.
Hospice treatment may be provided prior to requesting end-of-life care for a patient. True or false? This is false. Hospice treatment must be approved prior to being provided. A request is made by the physicians, then sent to and reviewed by the nurse consultants. When received, the nurse consultants begin the EOL worksheet, entering the information about the facility and the physicians making the request. The EOL worksheet is then sent to the guardian and their immediate supervisor for completion upon notifying the client's family. Nurse consultants ensure that all the necessary information is received and that this is medically appropriate. Nurse consultants summarize the client's medical status and what the physicians are recommending, then provide that summary to the Assistant Directors of Guardianship, Mike Handy and Jessica Wayne. Once reviewed, they then send it to the Director, Tanya Wells, for review, who then sends it to the Deputy Commissioner, Layla Williams, for review, who then sends it to the judge for final approval. Once approval is received via email back to the nurse consultants immediately telephone the facility to provide verbal approval. Written approval is sent to the facility at the first opportunity within office hours. When hospice is approved, there is a second set of papers that must be signed for them to begin treatment. These are hospice consent papers and must be signed by the guardian.
The nurse consultants receive a request for your client to receive comfort care, as there's nothing else that may be done to treat your client's condition. The physicians are requesting to keep the client comfortable. They request no more testing or antibiotics, no daily waits, allow the client to eat what they want, when they want, and to provide medications for pain and anxiety. The nurse consultant reviews the information and ensures it is appropriate request, begins the EOL worksheet, and sends it to you to complete. You contact the family that is listed under contacts in GFIS. The client's sister says that she was just there last June and the client was fine then. The sister wishes to continue full treatment and refuses to accept that the client is at the end of life.
If the client's sister states that she does not agree with the client receiving end-of-life care, she may petition the court to become his guardian over medical decision-making. True or false?
This is true. We would like to have the family's approval before moving forward with the EOL care request. If the family agrees, that's great. If they don't, they may petition the court for the ability to make medical decisions for the client. These requests are usually time-sensitive, so they need to be encouraged to do this urgently. If they are unable to secure medical decision-making powers for whatever reason, the Guardianship Advisory Committee will review the case and make the determination of whether to move forward with approval or not. Regulated services provided to those with terminal illness with a life expectancy of less than 6 months is hospice. To stop
life-prolonging measures such as mechanical ventilation, artificial nutrition, or hemodialysis is termination of life support. Specific to the physician's recommendation may include stopping blood draws, vital signs, etc. Implementing measures only to keep one comfortable is comfort care. A disease that cannot be cured or adequately treated that is expected to end in death is terminal illness. To provide symptom relief, not necessarily at the end of life, is palliative care.
Other important things to know. If nurse consultants are working on an end-of-life care request and the family mentions that they are going to pursue guardianship, the approval process stops temporarily, allowing time for the family to acquire a court date to obtain guardianship. If the family does not obtain a court date within a reasonable amount of time, the request will move forward with a review by the Guardianship Advisory Committee. If the case is urgent, the client is suffering, the family disagrees with the physician's recommendation, or the guardian is unable to locate or contact the family, the nurse consultants may meet with the Guardianship Advisory Committee to request approval to move forward with the request prior to receiving family approval. Please ensure that the contacts that are listed in your client's contact list are accurate and up to date. If you know that the physicians have been talking about end-of-life care for your client and you see that there are not any contacts listed, please do not hesitate to reach out to Janice Lunsford to locate the family contact information.
Now we will move on to requesting OLS approvals for removal of a body part.
OLS deals with non-emergency surgical removal of bodily organs, amputation of limbs, sterilization, or abortions. If a client has an appendix that is about to rupture, then that will likely be a medical emergency and will not require approval for surgical removal through OLS.
If the procedure needs to be performed within 24 hours of notification of need from a physician to preserve the life or prevent the serious impairment of the physical health of the ward, the field services branch shall not seek court approval.
Upon notice from physician of emergency need for surgery, field services branch is to notify the division of the need for an emergency procedure. Field services branch shall document the emergency need and timetable for the procedure and request an affidavit of emergency need from the physician. Field services branch shall review the affidavit if the affidavit is received and authorized as an emergency procedure as appropriate. The field services branch may request a second opinion and an affidavit from the second physician to verify the need for surgery is an emergency.
If it is not an emergency and you need to request assistance through OLS, the field services branch must obtain written statements from two physicians who have both evaluated the client and who are not in practice together. The letters must include the client's name, date statement was written, physician's name, area of practice, address, telephone number and physician's signature, date that the physician last evaluated the client, the procedure to be performed, date the procedure will be performed, client's prognosis if the procedure is performed, as well as a prognosis if the procedure is not performed, risk of performing the procedure, physician's opinion why the benefits outweigh the risk, and any alternative procedures that have already been performed.
The guardian shall then prepare a written request for legal assistance with the OLS in anticipation of a motion and order that includes the client's name, date of adjudication, date the cabinet was appointed, type of appointment and any limitations, county of current jurisdiction, court's case number, procedure to be performed, reason the procedure needs to be performed, person who will perform the procedure, location where the procedure will be performed, date of the procedure, reference to the two physicians who support the need for the procedure who have evaluated the ward and who are not in practice together, names, relationships, and mailing addresses of relatives to be notified of the court hearing.
The field services branch shall forward to OLS the following: request for legal assistance, copy of the court's disability judgment, copy of the district court's order of appointment of guardian, the two physician statements. If the motion and order have been received, the field services branch shall file the following information with the court in the case: the motion and order prepared by OLS, the 2 physician statements, the order of appointment of guardian, the disability judgment, and if required by the court, the Field Services Branch shall attend the hearing on the motion and order. The Field Services Branch shall provide a certified copy of the signed order to the hospital where the surgery or treatment is to be performed, or the facility where the ward is residing, so that the order can be sent with the ward to the hospital.
Always feel free to contact us if you have any questions, and we'd be happy to assist you in any way that we can. We hope that this video was very helpful and informative for you all. Thank you.